religious freedom, and to the best of my brief check, yes, we still only have the Declaration. So what I wanted you guys to do, if you could, is turn to your Declaration or pull it up on your computer out, however you want to do it. And let's have a brief look at what it has in there, if that's okay. Hello there. You guys have it? It's of 1981. So, ignoring the preamble, which is in any event not legally binding, to the degree, I wanted you guys to recall, because I was noticing our speaker kept making this mistake, and that is that a declaration is not a binding instrument. Its very name, declaration, means it's non-binding. It's a declaration of principles. It can, as we discussed early on in the course, it can also be a declaration of existing law, in which event it doesn't change the law, it merely declares it. And sometimes it declares principles that pass into customary law, but the declaration itself is not the source of the bindingness. Rather, because it's become a principle of customary law, it becomes binding. So when she said, for instance, and I've noticed some of you guys have used this language as well, the General Assembly adopts a declaration. It does not ratify it. It adopts it, okay? So keep that in mind when you're talking about the Universal Declaration, for instance. Okay, I'm answering a call. Hang on. What just happened? Lei, I was trying to answer a call. How does this work? I guess you'll call again.
You only have 6 people.
1, 2, 3, 4, 5, 6 still. Yeah, okay. Anyway, so I just wanted to remind you of the legal technicality of that. Once again, declaration is not legally binding. You do not ratify a declaration. You ratify a treaty. And notably, ratification is something that happens domestically.
If you had to choose, if you had to choose between being a cowboy or being a giant, what would you prefer to be? Wrong answer.
What
is it, a giant? If you had to choose between being a cowboy and being a giant.
Are we having wrong people?
Do you guys hear this?
Gainfully employed. This is doing really well. She's now a manager under masters. She's doing really well.
You are an excellent hostess.
What the heck?
Why are we running that?
This is incredible.
That was freezing. Is that?
This is incredible.
I didn't know they call on you or not.
I won't.
Why do you get my mom's headphones?
No, it's fine. I don't want to be rude.
Headphones, just put one ear in.
Are you sure?
Yes.
I really
You
don't
guys,
actually want
we're going to reinitiate this call because plainly people are on this call but don't belong here, okay?
Mine is the...
Okay, bye.
The
Andrew didn't go up.
People.
Yeah.
You have 9 people.
Hi there.
Hello. Hi.
Okay. So whatever that weird thing was, it seems to be gone. Did you guys hear a conversation about cowboys? Were you guys hearing that at your end?
Is there a bunch of people in your house?
Is somebody got a bunch of people in their house?
That's not your house?
It's not mine. Somebody know who that is? Lane, we're still getting this.
The security and Daddy's in here one time.
Any of these people that are not your students?
No, they're my students.
All of them? 12 of them?
Oh, there it's gone. Who is this?
You only have 5 people in your
Danielle.
call.
I think it must have been Danielle's house. Okay, good. Alrighty then. So let's get started. What I wanted you guys to go through a bit is the articles of the Declaration on Discrimination, religious discrimination, that is to say. So you want to start with Article 1, which is, again, preambles are just statements of principle. And usually they're about how come they are making this declaration. Sorry, I might have to take a break here in a minute. They're declarations of principle, whereas mostly about how come we are going ahead and negotiating a declaration, what's our motivation. And then the articles themselves are you know, the substantive content of the declaration. So going to Article 1, does anybody want to speak to RX? Tell us about Article 1. What's it about? RX, you there?
Yeah, I'm there. I'm just didn't heard you call my name. Article 1 is about just one's freedom to one's freedom of worship, to like one's freedom to hold the religious belief.
Okay.
And to refrain from the coercion of others and the government.
What about 3? Article 1.3.
It's one's freedom to express his religious belief, like to refrain from the limitation of the government of prohibition to manifest his religious belief.
Okay, so 1 is about freedom of thought, conscience, and religion, right?
Yeah.
2 is about coercion in whatever form it comes that would impair his freedom And what is 3 about? How is it distinctive from 1 and 2?
I think Article 3 is more like it from the freedom of expression, but in religious aspect.
Okay, so what would it mean? Andrew, what does it mean to manifest one's religion or belief?
The way I would take it is like you're actually practicing it in
Ah,
association.
keyword, that's what it's really. Practice, right? So what you are doing in the physical world to manifest your belief system, right? So what kinds of practices might we be talking about?
You know, going to congregation or service, going to like maybe evangelizing to other people or talking about it in the workplace, things like that. I don't know.
Okay, go on.
But yeah, like live it like making it a conscious part of your daily living. I would assume.
Okay, so let's depart from Christianity. What about other religions? How might they manifest their beliefs?
Perhaps dietary practices or praying practices, things of that nature.
Okay, how about clothes?
Clothing, yeah. Like we had a discussion several weeks ago about ultra-Orthodox Jews and flying, things of that nature, the types of clothes that they wear. And
Okay. So, for instance, wearing a headscarf would be a manifestation of one's religious belief, right?
yes, correct.
Wearing a yarmulke would be a manifestation of one's belief. Wearing a turban would potentially be, if you were a Sikh, you wear a turban and a ceremonial knife. That also is a manifestation of one's belief, right?
Correct.
So these are the outward behaviors that people engage in that are consistent with their inward beliefs, right? Okay, how about Article 2? What is it about? Something weird is going on. Okay, Doris is calling. Okay. Doris, are you not there? Hi. Okay, so are we all there? Oh, you guys can't see me now. Okay. Can you see me now? Cool. Okay. So back to Article 2. Anybody want to tell us about Article 2? How about you, Tatiana? You've been quiet all semester. Tatiana, are you there? Okay, Matt, are you there? Nadia.
Wait, so are we looking at the right? I can't even listen to. Hang on, just a second. Am I looking at the right document? Because I've been trying to follow.
Okay, so the document is Declaration on the Elimination of All Forms of Intolerance and of Discrimination Based on Religion or Belief.
Okay, so I'm on the right document. And we're looking at Article 2.
That is correct.
Right. Let's see. No one shall be subject to the discrimination by any state, institution, group of persons, or person on grounds of religion or other beliefs. And then, for the purpose of the present declaration, the expression intolerance and discrimination based on religion or belief means any distinction, exclusion, restriction, or preference based on religion or belief having as its purpose or as its effect nullification or impairment the recognition, enjoyment, or exercise of human rights and fundamental freedoms on an equal basis.
Okay.
Basically means that anyone cannot really discriminate on any basis.
What's interesting about preference? You still there? What's interesting?
Yeah.
Nadia, what's interesting about the last one, preference?
A second. It's based on, Would it be the right to choose whether or not to respect one's religion?
My initial reading of this, and I could be wrong, is that this may be the equivalent of the non-establishment clause of the Constitution of the United States. What do you guys think? Is that what it's saying? That you cannot be preferred because of your religious belief either. Anyone have anything to say to that? Francesca. Francesca. Oh, there we go. I'm sorry. I finally found Francesca. She's over here typing. Oh, Francesca's having tech issues. Danielle's having tech issues. Oh, okay, so I think we're to Francesca now. The question was, what do you think that the word preference means in Article 2, subsection 2? Did you hear me that time? We seem to be having a lot of issues with tech today. And anyway, in any event, let's go forward to the next article, Article 3. Among those of us who can speak, as opposed to who are sitting in the library, who can speak? Laura, can you speak?
I'm sorry, I just finally figured out how to get in the conversation.
Oh, okay, so we're looking at the Declaration on Religious Discrimination, which should be among the documents that's in your readings for today. That is for this week anyway. And we're looking at Article 3. So could you tell me what you think it means?
Okay. So this one is more about discrimination among people rather than government action that would suppress the ability to exercise a religion. Because this one, it's discrimination between human beings on grounds of religion. So
okay, so sort of drop state out of there, you think?
That's how it sounds to me. It's more of a citizen article.
Okay. And what does that tell us about the government duty in that event? What would the government duty be there?
Well, the government duty would be to ensure that the legislation does not permit citizens to discriminate based on religion. So to have enforceable rules that would provide freedom of religion to its citizens, and in that way ensure that.
So what is its duty, though? You said adopt rules. What is its duty? If something's going out on the street and there is and you know, let's say a Sikh person, you know, wearing a turban, mistaken for a Muslim person, is being attacked by a bunch of white Christian fellows, then what would the government's duty be?
The government's duty would be to act on behalf of the Sikh person and to hold the people who discriminate accountable for their human rights abuse against the minority or the religious person on behalf of it.
Okay. And as we know, most Sikh abuses take place because people don't know who Sikhs are, right?
Yes.
Which is a curious phenomenon all by itself. Okay, let's move on to Article 4. Who can speak now? Who's among our speaking crowd, by the way? I know Francesca is not. Is Linda? No, Linda is. Oh, Linda says she's having technical difficulties. Is Tatiana among our speaking group? She's not responding. Alexis! Alex! Oh, Alex. Oh, she says, I wish. I am at my office. No speaking at the office? Oh, she's typing. Okay, so go ahead. Tell us what you think of Article 4. Tatiana is also typing. Okay, I'm co-sharing a space and can't speak. Sorry, posted the last message. Okay. That would be Alex. Yes, we are looking at Article 4, Linda.
Should I just go for it, or I don't know?
Linda's typing. Give her a minute. Okay, Nadia, what did you want to say? And we'll read Linda's when she gets done.
Basically, states have a responsibility to prevent discrimination of individuals and respect their rights.
Okay.
Linda can, I guess, verify.
Okay, so what is, that would be 1, what is 2? So 2 is merely to do so by enacting legislation, right? Mm-hmm. All MS that sign on, ratify the declaration are obliged to ensure that effective measures are put into place to prevent discrimination relating to religion. Boo! Linda, were you not listening? Maybe you weren't here yet. Once again, you do not ratify a declaration. You do not even sign on to a declaration. In the context of the United Nations, declarations are adopted by the General Assembly by a majority vote, okay? So, no signing on, no ratifying. You may, in fact, from a political perspective, you may put out a statement that says officially, we embrace this declaration, we support it, but it is not binding law unless and until it either passes into customary law, or, as I said, if it's a statement of already existing law, that is to say, whether it's customary or whether it's part of a convention, then it may be law. But the reality is, if you are trying to develop progressively the law about something in a declaration, then all you are doing is engaging in a statement of principles, hopefully a goal that you hope eventually to reach, most probably through implementation in the context of a convention, okay? So please remember that. Alrighty, so let's see, Article 5.1. Andrew, I'm going to pick on you again. You there?
You said Andrew, right?
Yes, I did. I said you.
Okay, so Article 5.1, you're going to pick what is, says the parent. Well, what's your question about it then?
What is it about?
Oh, this is sort of in frame with what we talked about, I think it was 2 weeks ago. It says that until a child is of legal age, basically, the parents have the right to organize their family life in a way that reflects particular religious beliefs.
Okay. So the state basically cannot override the family preferences for their children, right?
Correct.
Or parental preferences for their children. Stick
And
with
then
me.
also, I guess by implication that means, at least in the United States, a child wouldn't have rights to their own, any legal rights to their own religious beliefs until they're of legal age, essentially.
Okay, well, obviously, the curtailment of a child's mind is virtually impossible, right?
Mm-hmm.
But do they have, the right, let's say, to go off and without their parents' permission, and investigate another religion or a secular belief? I think the more concerning issue is not necessarily that the child can't go out and investigate. I think the more concerning issue is that the state can compel the child. Do you understand what I'm saying?
Yes. Yes.
So I think that that's the primary concern, is that the state sort of goes into the home and commands the child to adopt a belief system that is inconsistent with the parent's own. So,
Indeed.
but if the question is, do children have as many rights in this regard as their parents, I think the answer probably has to be no, at least not in the current stage of development. So what is your objection to that? Andrew, I'm asking you.
Do I have an objection to that? Let me see. Let me quickly read over again the following points. Well, it seems to make room in Article 3, no, sorry, Article 5, subsection 3, that the child also has a degree of protection of their own beliefs.
Okay.
So there's like this balance between the parents wanting to organize their family life in a certain way, while also making a little bit of room for the child not to be discriminated against their own opinions.
Okay.
As they come of age. Would you agree that there's a little bit of room for that?
Let's see. The child shall be protected from any form of discrimination on the ground of religion or belief. He shall be brought up in a spirit of understanding and tolerance, friendship among peoples, peace and universal brotherhood, respect for freedom of religion or belief of others, and in full consciousness that his energy and talents should be devoted to the service of his fellow men. So who do you think bears that duty? Is that the state that bears the duty?
It certainly does not specify. I think to your point, the state could come in through, liberal education or any other form of education to fill that void.
Right. So
But
I don't think that is directed at the parents. I think that's directed at the state, right?
it seems to be more of a directed, at the society/state. That there's a responsibility of all involved to make sure that they're fostering this type of accepting environment.
Okay. How about number 4? So
this means for instance, if a child is not under the custody of their parents or guardians,
so what might that be?
If they're living in some sort of, orphanage or...
Okay, so maybe the parents are dead?
The parents are dead, and they have no legal guardians. It's basically compelling, and my guess would be, it's basically compelling the state to come up with some sort of safety net for them to be brought up in a way that allows their religious and personal beliefs to develop.
So let us suppose then you're the appointed guardian through a parent's will, right? And the parent says in his will that I want my child to be raised as a Jew. and you have an agreement with this individual. I mean, this is not coming out of the blue. You have an agreement with this individual whom you have great regard for, that they are going to go ahead and step in the event of your death. However, they happen to be Christians. So what is your obligation under those circumstances?
That's an interesting case. Because I also feel like if the guardian in this case was a Christian, they wouldn't necessarily be capable of giving the child a comprehensive Jewish religious education. You know what I mean? So that guardian would have to take it upon themselves to learn a lot about the faith as well in the process of educating this child. It seems then that they would be compelled to do that to the best of their ability if they wanted to honor this individual's will.
Right. And it would suggest that at the very least that to some greater or lesser degree the will must surely be binding on the guardian of the child, right?
Because the way you set up this hypothetical, it sounded like the guardian, before the parent died, had said, yes, I am willing to do this should you die. So there was an agreement made with...
Well, let's suppose that what happens instead is that the guardian, for whatever reason, I wrote my will. I really never imagined I was going to die before this other person, and I'm going to be around to see my child into adulthood, and then I get into a car wreck and I die, or maybe a plane wreck. And I never had the opportunity to have that conversation with the person I appointed as my child's guardian. What then? Does that make a difference for you? At that point, I should think that, in any event, I would think it would be before the courts, because the court ultimately decides, in a circumstance like this, who is going to be the best guardian and act in the best interest of the child. But
so would the court then look holistically, basically at what was the overall intent of the will, and then decide based on that the circumstances that can best fit the holistic understanding of the parents' wishes?
Right, but let's suppose that the person, the guardian, the appointed guardian, again, let's assume it's a Jewish parent and a Christian, guardian, and the guardian says, I absolutely love and adore this child. I had a very close relationship with my friend who is now dead. I want to take care of this child, but for the reasons you've just said, I do not feel that I'm in a position to raise this child as a Jew, and hence I will be compelled. I feel it's my obligation to imbue this child with some moral understanding, so I'm going to take him to church. What would you as a judge say then?
I don't know if the judge would really have too much of a problem with them also exposing them to church, so long as they were also making an effort to provide a Jewish education as well. And that might also be in keeping with one of the themes of Article 5, that the child should receive some type of cross-cutting, universal, ethical and religious upbringing. So learning about other traditions doesn't necessarily negate that.
Yeah, but let's suppose that this happens fairly early in the childhood of the orphan. Don't you think that would constitute conversion? And is that ethical under the circumstances? Nadia, you started to say something.
No, but can you repeat the question?
Okay, so basically we're saying that the child loses his or her parents early in life. Mm-hmm. The parents, want to go ahead and give guardianship to this other couple or individual, as the case may be, who happens to be Christian. They have gone before the court. They said, look, we love this child. We love this child's parents who are now lost to us. We want to go ahead and take on this obligation. However, we don't feel that, as Andrew suggested, we don't feel that we can adequately teach this child about Judaism, but we do feel that we need to go ahead and imbue this child with some kind of moral understanding, so we're going to drag this kid with us to our church instead. Would that be a problem? Should the judge say, oops, no, because they were very specific about this in their will?
I think the parents would get some sort of leeway.
Which parents are we
Specifically,
talking about? Are
if
we
they
talking
have
about the
decided to
adoptive parents, or are we talking about the parents who are now dead?
The guardians. Sorry.
Okay.
Guardians would get some sort of leeway if they proposed to the judge and said, look, you might have bought a pamphlet of any kind to teach about the Judaism, to teach about Judaism, to expose the child to the religion of the parent's preference, but this is the extent of our capability, and we can't be expected to fully uphold another religion as we're practicing our own beliefs. So I think as long as the parents were to show some sort of satisfactory fulfillment of that, the guardians were to show some sort of satisfactory fulfillment of the original parents' will, I think they would be fine in front of the judge,
Not
If I'm a guardian in that sense, I can't be expected to fully practice a religion that wasn't mine.
But they're not saying practice this religion. They're saying teach this child this religion. Which doesn't necessarily include subordinating your religion to theirs, does it?
No, but if you were to raise another child in a Christian household, for example, and the parents were to go to church every week as part of their weekly activities, or they were to have Bible study in the morning, you can't tell the parents that they shouldn't be allowed to do what would be normal for them, or what they're able to do, if that makes sense.
But what if they go ahead and they take the child to temple or synagogue, depending on the form of Judaism, Friday night, and child has an opportunity to sit through services, and then Saturday, you enable the child to observe the Jewish Sabbath, and then on Sunday you go up and you do your church thing, and kid stays with maybe somebody else that morning. Is that a problem?
I think that's a fair compromise. So as long as the child is still exposed to what was written on the will, which is that it would be raised with some Jewish beliefs, then I think that would satisfy the part of that will.
Okay. Would it be hurtful to the child? Would the child feel that they were now being discriminated by their new family? By not being, fully embraced by the family at that level?
I mean, the child would have to understand the circumstances at some point and realize that if they're being raised by guardians that are not Jewish but are trying their best and are exposing them to Jewish beliefs as per his or her parents' will, then there isn't much to argue about. There isn't much of a room to say, well, I have a case if we could have done more Jewish things. Instead of Bible study in the morning, we could have read the Torah.
Okay.
It wouldn't really hold up in court.
No, but we're not necessarily saying that. That's not really my point. My point is a different one. My point is that the child would feel as if they were being separated from, let's say there's other kids in the family, from the other kids, because they're being sent one place while all the rest of the family goes to another place on that day. That is to say, that Sunday morning. So would they, by trying to sort of set up some kind of wall or barrier to ensure that this child really is getting, more or less exclusively a Jewish education, is it possible that they would then feel they were being discriminated against by their own family because they're not permitted to participate in the family's main event, which is that Sunday morning activity?
I think it would depend on the child to ask what its preferences would be. Would it want to continue living up to the parents' will and be explained that this is what your parents expressly chose for you and for your life? But also to see what the child would prefer.
So Andrew, is this where you would say it's time for the kid to have a vote? Hello? Andrew, you still there?
Yeah, sorry. What I was saying is I think we're getting to the point where the child needs to have some sort of input here. Or there needs to be some sort of provision in any court agreement that is reached that discusses when can the child assert their own judgment, what tradition they'd like to be a part of.
So would this turn on their education? Would this turn on their age? Would you feel differently if this child were 5 or if this child were 12?
I would definitely think that's a relevant consideration. Because especially by the time you're 12, you're fully capable of starting to figure out how you feel about certain things, ethical issues, religious issues, and also like how much you want to fit into the guardian's family. You know, like that's a relevant consideration as well. Would not being able to fully participate in family's spiritual life prevent the child from, you know, from being a part of that family in a full way? You know.
So Danielle and Alexis both think age should be pivotal in this thing. But this is the interesting question I have for you all. And isn't the harm going to be greater when the child is younger and has less capacity to understand why they're being directed towards down one path rather than down another? I mean, if the child had been orphaned at 12, the kid would already have enough understanding to say, okay, you know, they're just trying to implement my now dead parents' wishes. Whereas at 5, they're just saying, well, you know, how come I don't get to play with the other kids? Okay, Francesca is saying, I think it is also psychological development. So obviously this would be a tough issue. And it's one that's been around for a while. I don't know if you guys ever saw the movie about Gandhi. But the reality was, in terms of Gandhi, that I don't recall whether it was he adopted a Muslim child during that very difficult time when they were partitioning India, or whether it was one of his followers. But basically, you know, I believe it was one of his followers who, you know, perhaps was engaged in violence as against the Muslims, and then, you know, adopted this child. And this child was of Muslim heritage, but the Hindu father felt that he could not abandon this child now that his parents were dead, and so Gandhi said, look, raise this child as a Muslim. Danielle's writing, the frontal lobe, which services executive functioning, decision making, etc., doesn't fully develop until 23 through 25. Yes, we are still on that. So Danielle, why is that relevant here? I mean, obviously we know that decision making among children, any children, is going to be not fully mature, but we also want to consider whether we are making them feel safe, loved, and embraced. So what are we going to be doing with this child? Danielle's typing. Type fast, Danielle. I think, obviously, the reason why, okay, so the child's agency shouldn't matter until probably the latter half of his or her teen years. Okay, well, that's pretty tough. But what if we have a very mature, very intelligent child who maybe is in a better position than many children to make these kinds of choices? Doesn't say if she's still typing. Anyway, so this is really the tough question, I think. Not so much the impact on parents who obviously can withstand scrutiny, but the impact on children in terms of these kinds of considerations. We talked before about what happens when we sort of impose, you know, the state's viewpoint on children, and through children on their family. Last week or the week before, I guess it was last week, right? And, you know, do we force children to learn about evolution when their family happens to belong to a creationist creed? And what would be the impact on the family were we to do that? Because obviously, if the child, that is to say, embraced what teacher says, then when mommy and daddy say something different, then there's this sort of cognitive dissonance, which we talked about before. In any event, so Danielle is still typing, but let's go on to, sorry, having difficulty seeing the page here. Practices of a religion or a belief in which a child is brought up must not be injurious to his physical or mental health or to his full development, taking into account blah, blah, blah. Does that, remember our discussion about the Frohock and Christian Scientists? Does that apply there? So if I'm praying over my child, hoping that my child will get well as a product of my prayer, but the child dies of a preventable illness, and this is what the Christian Scientists were being prosecuted about, is it relevant that, you know, because this is a child, we should consider the child's medical health before the parents' religious practices and their faith in various forms of spiritual healing?
I think, can you hear me?
I can. Who's there?
Okay, this is Matt.
Hey, Matt.
Hi. So I think in this case, that would be considered a practice of a religion or belief in which a child would sort of be subject to injurious treatment due to his or her physical or mental health. Just because in this case, under the Christian Science doctrine of sort of abnegating oneself from medical treatment would very directly lead to medical harm. So in this case, I think the law would step in.
But should the law prosecute? Let's suppose that I am not particularly well educated. Maybe I am well educated. But, you know, I'm one of those people who always holds off going to the doctor. And I'm looking at my kid, and my kid doesn't look that bad to me, and I say, I will wait until tomorrow. Tomorrow we get to the doctor, kid still doesn't look all that bad, except for that within 24 hours kid dies. How do you distinguish that from the person who is engaging in religious healing practices of one sort or another?
Well, I mean, that's clearly like a difficult sort of distinction to make in practice in terms of what are the reasons behind sort of not taking a child to treatment when.
But these kinds of things happen all the time, right? I mean, they actually do. May I say, just as a pause here, we have a cat. We had a cat who died last summer. Kitty looked, you know, a little bit gone, seemed to be off its feed. We finally decided, you know, to bring the cat into the veterinarian, and literally within 24 hours the cat was dead. But there was nothing on its face that was made clear that Kitty was that ill. So if it happens with one's pets, surely it happens with one's children as well. So do you get prosecuted for murder for that?
No, not in that case. I mean,
then why would you be prosecuted for murder in the event that you were engaged in faith healing and the child succumbed to its illness anyway? Why murder? Isn't that a pretty heavy duty way of dealing with it?
I mean, okay, so in that extreme, then yes, that would be like a heavy-handed sentence. But I guess sort of
a heavy-handed charge. Actually, it was a charge, and they were actually prosecuted on murder charges, and they were in, as I recall, some of them were actually served jail sentences. So the question is that how you deal with this issue, or should there have been, like, perhaps, you know, made clear beforehand, you know, look, you know, if you can pray all you want over the kid, but, you know, if kid's getting sick, you go ahead and you take him to the hospital and you pray there.
Right.
Would that have been a more reasonable approach than saying I'm gonna throw you in jail because you believe that your religious practices were superior to our medical view?
Well, I think that would be a more appropriate response. Although I guess in that case that would be a more appropriate response.
I mean, because basically what they were doing here is they were treating people who believed in religious healing the same way they would treat somebody who you know, brutally beat their child. And I don't think, I mean, you know, correct me if I'm wrong, but it seems to me that those two situations are not properly comparable.
Right, they're categorically different. And I think also the case of withholding medical treatment, that'd be different than if, for example, say the child was already in the hospital and then the parents then decided to refuse treatment for the child on religious grounds. That, I think, would be a prosecutable offense. Whereas,
except for whoops, hold it there. What if the doctors say, we've decided that we're not going to treat your kid anymore because your kid has a illness that we find, or we don't have any means of treating? Or we think that the child is going to suffer more if we continue to treat it, then it's worth causing the child to suffer. How do you distinguish that?
Well, I think that's them honoring the Hippocratic Oath, first do no harm. So in that case, no. I think that would also be categorically different from, say, murder.
Yes, or it's euthanasia. Is it euthanasia?
I don't believe so. Euthanasia would be actively killing. I think that's, again, I think these are categories.
Okay, well then, so the doctor can withhold treatment in a world where not 20, 30 years ago, a doctor would have to continue to pursue treatments until there were no options left. But here we're talking about, and the doctor will not be criminally prosecuted. In fact, the doctor can even take the parents to court and say, I want a declaration saying I don't have to treat this child further. But if the parents say, I want to go ahead and, treat my child basically by a means of alternative medicine, then they can be not only taken to court, but they can be criminally prosecuted. Is there some kind of maybe uneven terrain here that we need to negotiate?
Well, I think that's obviously a very difficult sort of spectrum to deal with in terms of what is sort of legally actionable and what's just what necessitates a sort of serious conversation of what is considered responsible and what's considered criminal. I think not recognizing, say, illness as something that needs to be medically handled, I think that's perhaps irresponsible. However, I don't think that's the same as, say, murder. I think those are different categories and should be handled differently. I think where it would be, where there would be a case where legal action could be taken, where is if a person who sought medical treatment for an illness was prevented from doing so due to religious concerns, because at that point, then religious freedom would be sort of preferenced over the right to health. And I think that's a very, very difficult sort of relationship to negotiate.
Okay. Alrighty, so let's move on. If you look at Article 6, you will note that it has a series of additional rights that follow upon, that are part of religious freedom, to worship or assemble, to establish and maintain appropriate charitable or humanitarian institutions, to make, acquire, use articles and materials related to one's rights or customs, to write, issue, and disseminate relevant publications, to teach a religion or belief in places suitable for these purposes, to solicit and receive contributions, to train, appoint, or elect clergy, to observe days of rest, and to celebrate holidays, and lastly, to establish and maintain communication with individuals and communities in matters of religion and belief. Do you see, I'm not sure, anybody see something here that suggests that proselytization is okay, and why would people not be comfortable with the concept of proselytization, meaning going to persons from, basically trying to poach people from other religions, or from no religion, as the case may be? Anyone? Anybody have difficulties with the concept of proselytization? Oh, come on.
Can you repeat that, Heather?
What is the problem with the concept of proselytization?
Can you explain the proselytization again?
Okay, proselytization means that I go out and I preach to people who are not members of my faith. Maybe I, like the Jehovah's Witnesses, I go from door to door knocking and ask for an opportunity to talk about my religious faith. Or, maybe I go abroad, I become a missionary, and I try to convert people in the Congo to my religious faith. So that is what it means to proselytize, is to try to get people to convert to your belief system. Is that a problem? And if so, why? Anybody know what the Muslim take is on this? was there? Matt, what's the Muslim take on proselytization?
So I'm not fully familiar with sort of their practice of proselytization. I can only speak to sort of the Catholic experience.
Okay, cool.
But I think in theory, there's nothing inherently wrong or discriminatory about proselytization. I just think, depending on how zealously it's carried out, it can look in practice very similar to discrimination, especially if it's couched in language such as like, you know, do this or perish, or like you must repent, or somehow you are sinning by practicing your genuinely held religious belief. So I think there are very important sort of qualifiers here. So I think, generally speaking, no, not discriminatory. However, it can be, depending on how aggressively it's pursued.
Okay, but that's not really the issue. The issue, let me step back from that. That is an issue. I mean, if I'm at school and I'm a young kid and maybe I'm a teenager, and people keep coming at me with their religious beliefs, trying to convert me, then plausibly I would feel certainly discriminated against, and yes, okay, I'll agree with you, that could be one of the downsides of proselytization. But the fact of the matter is that Islam has a big issue with proselytization, because to convert from Islam is, anybody know? Talked about this before, back when we were on minority rights. What is the cost of converting from Islam, at least among the more serious, more conservative practitioners? Anybody know? To leave the faith.
It's apostasy.
It's apostasy, and what does that mean?
It's the worst sin, I think. In
Islam. It's not just a sin. It's more.
It's punishable by death.
There you go. So yeah, so if you take the position that leaving the faith is a capital crime, then probably it would be a bad idea, right? To try to have permit people to come into your country and proselytize them, unless you sort of see it as the equivalent of being tested by Satan, as it were. Linda says, no, I do not think Muslims believe in or support conversion by force. Actually, they don't believe in are you talking about converting others by force? Or are you talking about because they certainly have a history of converting people at the point of a sword, as unfortunately does the Roman Catholic faith? Or are you talking about they don't believe that their own should be converted by force, which we would certainly agree to? No, their own, I see. Yes, well, absolutely, that's true, but the reality is that they do not even want people to come into their countries and talk to them about other religions and tempt them to leave Islam. And you are also probably aware that while Muslim men can marry women from at least the other Abrahamic religions, women cannot. The idea being that a man has a stronger mind and will not be tempted to leave the faith by a woman who happens to be a Christian or a Jew. Whereas in the reverse, the supposition is that a woman will be compelled to submit to the religion of her husband. So that is why she's prohibited from marrying outside of her faith. Okay, so let's go on then. If you've read Dreenen's book, then you know the thesis of it is that religious freedom is only protected in a declaration, and that we need a convention on religious freedom. Obviously, he also sort of conveys, although wrongly so, that that the concept of religious freedom is new. It is certainly true that it has never, unlike other enumerated rights, ever been developed fully into a convention, at least up till now. So why would we need a convention? Religious freedom was, in fact, as you undoubtedly know, the first human right. It was born with the Peace of Westphalia in 1648. It has undergone since considerable development since that time, and certainly, like every human right, it has not been even-handedly applied. Basically, one had the protection of the freedom of religion only if one was a Christian of some kind. Second, he claims that there is only a declaration on religious freedom, but that, of course, is not accurate. As you undoubtedly know, it appears in the Civil and Political Covenant, and also the Universal Declaration, and undoubtedly the principle of religious freedom, if it was not already part of international law, as a customary principle of the law, surely by now it has become so. So the Declaration merely further develops this already existing right. So is the drafting of a convention on religious freedom necessary? Well, he's concerned, among other things, with having a judicial or at least quasi-judicial body that would have authority over this area, one that would be comparable to the Human Rights Committee or CEDAW or the Committee on the Rights of the Child, etc. So he wants greater intervention specifically on the issue of religious freedom. So the question is, what would it add, since actually the Human Rights Committee does in fact already oversee the implementation of this principle within the context of the Civil and Political Covenant. So what would it add? Drinan himself questions whether the decisions of a quasi-judicial body would have any effect on the most contentious issues relating to the freedom of religion. For instance, would Muslim nations observing the Sharia, or at least requiring that no law be in conflict with Islam, permit greater freedom to its minorities? Is it likely that it would permit proselytizing? Would it permit Muslims to convert without consequences? Would China, which actively promotes atheism, permit proselytizing by religions of non-Chinese origin? Would former colonial states welcome proselytizing by groups coming from their former colonial metropoles, as obviously happened at the time that they were colonies? Would a convention, together with an oversight committee, effectively put to rest once and for all the phenomenon of anti-Semitism, which, in point of fact, as a historical matter, led to the entire human rights enterprise? Anybody want to comment? And then we'll take a break.
Would you be able to repeat the last part?
Okay. Would a convention, together with, a committee to implement that convention, like the Human Rights Committee, but committed exclusively to the protection of religions, of religious freedom, and the prevention of discrimination against religious groups, would that in any way address any of the problems that he listed, or indeed any of the problems we might observe in the world where there are contentious issues between various faiths? Would it help? Maybe I should ask the lesser question, would it hurt? Laura, what do you think?
I don't think that you could argue that it would hurt, but that's basically the question of international law, is if making a convention that upholds any kind of human right is actually an effective thing in changing people's behavior. So if you have a convention that states agreed to uphold religious minority rights...
Yeah, but we're not exclusively really concerned with religious minorities, are we? Because the state may, like France and I think increasingly the United States, a state in fact may have an interest in actually oppressing the majority view as well. Isn't that possible? So we're not really only concerned with religious minorities here.
Right. Well, in any case, if the point is to uphold religious freedom in any context, to have a convention that states agree to and therefore must create legislation like that will infiltrate how they run their public schools, how they allow proselytization, and all of that. Whether or not that is actually effective in countries like China or countries that are secular is basically the question of international law, right? So
maybe we should leave that to next week when we talk about what is the future of human rights and how effective they are.
Yes.
Okay, so we shall come back to it. Let's take a break. I will be back in, let's say, 10 minutes, okay? Okay, okay. Sorry about that. I forgot. Okay, so I'm a little bit early, but we might as well move on to economic, social, and cultural rights. This is right up there, obviously, with environmental rights in terms of how warmly received it is here in the United States. As you probably know, it's highly contested, just like environmental rights are. Clearly, whether individuals possess these rights has been treated almost entirely as an ideological issue. Economic and social rights were associated with the communist bloc during the Cold War, even though most Western states became welfare states following the Great Depression. Social justice was hardly alien to the US. Indeed, from Theodore Roosevelt's Republican administration, which launched trust busting against the vast holdings of the most wealthy. Through the years of FDR's administration, there was agreement among elites, and this is very curious. There was an agreement at that point in time among elites across party lines, Republican and Democrats alike, that progressive legislation leading to the establishment of the welfare state was in fact desirable. That bipartisan consensus began to break down in the US, which carried most of the economic burden of the Cold War in terms of military defense after World War II. Following the war, most European states built down their defense structure so that they could focus instead on rebuilding their tattered economies, including, of course, on their tattered economies, and I seem to be including, of course, their devastated infrastructures. While the U.S. had a hand in the initial reconstruction of Western Europe with the Marshall Plan, as we all know, the failure to contribute to the defense budget, defense burden, that is to say, began to infuriate the U.S. So when you hear Donald Trump saying NATO should pay more money, it's not a new complaint, it's an old one, and it's been around for a very long time. The Europeans continued to expand their welfare states while complaining that the U.S. was not sufficiently leftward leaning, and simultaneously complaining that the U.S. was not adequately protecting them if they felt threatened by the communist bloc. Indeed, the U.S. was called upon to shield Europe with its nuclear arsenal, or umbrella as it was called at the time, thereby enabling Western Europe to avoid the cost of developing and maintaining a nuclear force, although obviously the French and the Brits both had a smaller force of their own, as well as carrying their share of maintaining a conventional force capable of deterring aggression by the communist bloc. The U.S. Was least affected by which was, of course, least affected by the devastation of World War II, was compelled by these circumstances to assume the leadership role of the so-called free world with all of the attendant costs. By the time that he ran for president, JFK, a Democrat, actually ran on a platform that was further to the right than Nixon, the Republican nominee. And it was for that reason that Eleanor Roosevelt was not a friend to JFK. And interestingly also, Eisenhower was not a friend to Nixon during the presidential campaign and refused to endorse him. He wanted to disassociate himself from, that is to say, JFK wanted to disassociate himself from FDR and communism in the post-McCarthy era and firmly establish his credentials as a Cold Warrior. So the anti-war movement of the 60s and early 70s pushed the American electorate to the left, in America, if not actually in European terms, but then of course a huge backlash was to follow. As a result, during the 80s and 90s, the American welfare state was effectively dismantled amidst a relatively strong economy, with Bill Clinton, a Democrat, delivering the coup de grace. Oddly enough, this was likely a survival strategy on his part, as the electorate had moved continuously to the right, even after the conclusion of the Cold War. For some, this came as a surprise. When the threat of nuclear war had all but ended, the hope of many had been that there would be a so-called peace dividend. In fact, Teddy Kennedy constantly, everywhere he appeared, he used this refrain that now that the Cold War was over, we should focus on domestic affairs and we should enjoy a peace dividend, and that the U.S. could finally turn inwards and address its own needs. To the contrary, those peace dividends were never realized, while economic and social rights, never abandoned by many European states, had been rediscovered throughout most of the world prior to and during the Great Recession. Comparatively wealthy states like Germany and the US continued to insist on the neoliberal austerity measures that were first launched during the Reagan years. Initially used to address the economic distress of the third world states, they had finally started being applied at home. Tightening one's belt continues to be the watchword for both states, even though the effects have been disastrous for most people, as the gap between the very rich and the rest has grown ever wider. From the perspective of many, I'm sure, I don't know if you guys watch CNN, but there was a report on Fareed Zakaria, talked about the fact that Bill Gates, who is the guy who owns Amazon?
Jeff Bezos, I think.
Okay, and who is the big investor?
Or the Washington Post, or?
No, the investor, who has made a tremendous amount of money on investment. Older gentleman, friends with Bill Gates, has contributed to Bill Gates's fund. This is frustrating. I can see his. This is ridiculous. Hang on just a sec. Here we go. Warren Buffett. So take those three people, put them together, and they hold more wealth than the rest of the population combined. Thank you, Tatiana. Yes, Warren Buffett. So those three people alone hold more wealth than the rest of the American citizenry combined. So is that shocking? Should it be that way? I've told you that there are pockets of desperate poverty all over the country, and I happen to live in an area where that poverty is readily observable. We continue to see houses even now go into repossession by banks, and of course, as I also told you, there was a second round where houses were being taken by the state because the owners had been unable to meet the taxes. So is that okay? Is the correct response to that belt tightening? Anyway, so from the perspective of many, even worse has been the devastating effects on our infrastructure, which was built up in earnestness after World War II by President and former General Eisenhower as a means not so much of expanding our economy as our defenses, though it had the effect, obviously, of doing both. So, as you probably know, Eisenhower was primarily responsible for launching the building of the interstate highway system that we have, although obviously over the years it's been expanded, but he was the individual who launched it. And he launched it on the theory, as I said, that it would aid in the defense of the United States. It can reasonably be said that we are now in the position of the U.S. at the turn of the last century, before Theodore Roosevelt became president, with the same extremes of wealth and poverty. So before we address the possibility of reestablishing at least minimum economic and social rights, let's begin with some relevant terminology. First of all, and we've talked about this a little bit before, interdependence, and indivisibility of human rights. we've encountered that concept, as I've already said, but we haven't really fully discussed it, but it is an easy concept to grasp. The International Bill of Rights, including the Universal Declaration, the Civil and Political Covenant, and the Economic, Social, and Cultural Covenant, were not to be treated as a menu of rights from which one may select a la carte. Rather, they were interrelated and equally binding on all states' parties. The problem is that the United States never agreed to this interpretation, particularly during the Cold War. Obviously, civil and political rights, as well as the Genocide Convention, were adopted in large part because of the Holocaust. There was a deeply felt need to ensure that this kind of barbarism would be outlawed. Clearly, the Great Depression played a role in bringing the nightmare about, where economic and social rights are neglected and strong inequalities assert themselves. Social tension and turmoil erupts that invites a strong man like Hitler or Mussolini or Stalin to sort of step into the breach. And does anybody see a connection here with the gentleman who currently sits in the Oval Office? What was the appeal of Donald Trump?
The appeal of Donald Trump was that he was going to make America great again. I know, economically at least. Not so.
But what is it that he conveyed that people sort of glomped onto? He goes around and he says that he admires Putin. He admires, I can never remember his name, I'm sorry, the North Korean dictator. Kim Il-sung? I can never keep track of that lineage, but in any event, so he actually says nice things about these folks, and then he dumps on Western democracies, for instance. So, what was the appeal? What was he selling?
He was selling strength.
Right. Exactly. America first. We're going to be concerned only with ourselves. You know, I'm the kind of guy who is going to be able to put this deal, quote and unquote, together. I'm going to make this work. We're no longer going to have folks in poverty, especially, I suppose, white folks, who had come to believe that every generation their economic situation should improve, and suddenly that has been brought to an abrupt halt. So that's what he was selling. So not dissimilar from what was happening after the Great Depression. Now, mind you, there are plenty who would argue that FDR was similarly a strongman. He was highly paternalistic. He did his thing by the fireside, in the fireside chats. And, you know, he was even willing to go so far to make sure that his his economic proposals went through. He was willing to pack the court. Adding additional Supreme Court justices in order to ensure that they would find his legislation constitutional. So there's a saying among constitutional scholars: "A switch in time saved 9." That is to say, there was a swing vote that ended up supporting his measures, and then the Supreme Court was not reconstituted to ensure that outcome. So he certainly was a strong man. For all that, one could equally argue that Abraham Lincoln was a strong man. So I mean, in tough times, we find strong men appealing, don't we?
Yes, but I think that Lincoln is different from Hitler.
Okay. Fair enough. I'm not going to argue that point, but nonetheless, he was most definitely willing to circumvent the law in order to achieve his objectives.
He was, but with the case of martial law in New York City, he did it in response to rioting. He wasn't just like, you know what, we're going to do this.
Okay.
Once they rioted, then martial. So yes, not good, circumvents the law, but he wasn't just doing it for the help, I guess.
For the help?
Yeah, he just wasn't doing it for the hell of it. He was doing
I'm
it
shocked! Did you say hell of it? Yes.
Yes.
Okay, so you think that that we can make a moral distinction between strongmen who are seeking to do good as opposed to strongmen who are seeking to do evil. But the question is, do we want to have strongmen at all, or do we want people who follow the law? And who gets to decide what is good and what's evil in circumstances like these? There were plenty who thought FDR was absolutely evil. I'm sure there were plenty who had no love of his predecessor, TR. So who gets to decide what's good and what's evil? Is it different when the question is economics rather than civil war? Bye, Alexis! If she didn't hear me before. Do you think there's a difference? Who's umming here?
I think there is a difference. In Civil War, you're trying to preserve the country as a whole, as opposed to economics, you're going after abstract ideas of what people think is good and what people think is prosperous.
So the fact that FDR was trying to lift up the starving masses, it was deemed by many as an evil act. Was he an evil guy, or was he a good guy?
I think he's a very complex guy who did some really bad things, and also did really great things.
Okay.
Like Social Security, I say good, but then turning away boats of Jews fleeing Europe, bad.
Yeah, but let's just focus on what he's really hated for. I hear what you're saying, yes. At that time, there was a real problem with his treatment of the Jews, and you also have to know, he also, who was the guy who was the Treasury Secretary, was it the Treasury Secretary who brought this issue to him? And basically what he said was that, I don't want to do this, but you need to go out there and persuade everybody so I can stop doing this. So he was preserving it. That was sort of a matter of expediency, wasn't it? Because anti-Semitism was a broadly held perspective here in the United States. And so he felt that he was under a compulsion to behave as he did, but he didn't necessarily want to do that. So, or so he said, or so it's represented. So is he, let's put aside the fact that he was acting with political expediency in that particular connection. You also know he wanted to get into the war badly, right?
Yeah.
I mean, that was a big issue, is he wanted to get into the war. There's some issue about why didn't the Allies bomb, the railways leading to the camps. Did they not care, and that has been also much debated. So in any event, but let's just focus narrowly on his effort to lift up people following or during and following the Great Depression. Was he a bad guy? RX, why don't you have a say?
I just want to make sure we're talking about Roosevelt, or?
I'm sorry?
Who are we talking about? I just want to make sure.
We're talking about FDR, that is Franklin Delano Roosevelt.
Oh, yeah, I just want to make sure. I think from what I learned in Chinese history class, I think he is a good guy because if we see the outcome of his policy, like he did help the American to overcome the negative consequence of the Depression,
right,
and like make the economics boom again.
Okay. So you think he did a good thing by trying to lift him up, or lift them up?
Yeah, I think so, and I think whether a strong leader is good or not, I think it largely depends on the consequence of his policy. Like we can't judge judge him
Right.
based on the measure he takes, but only when there is an outcome of that measure we can like give him a fair comment, a fair judgment.
Oh, here we go. It was Henry Morgenthau that was the individual who approached FDR and said, you have to help us. You have to do something about the Jews. And then basically FDR said, I want to do something about the Jews, but you have to go out there and persuade everybody that I need to do something about the Jews. So anyway, going forward, I'm sorry for that. But anyway, so your feeling then, RX, is that what he did was basically a good thing.
Yeah.
But then, forgive me, but given your own background and the country in which you were raised, that would be a natural position for you to take. Do we have any conservatives among us who would take the opposite position? Grant, what do you think? Are you? I'm assuming you're conservative, rightly or wrongly. What do you think?
Then I'm a conservative.
No, possibly not. I'll take that back. Boo boo. Okay, let's try Matt instead. Matt. He doesn't want to be labeled as a conservative either, but at least put forward what you think the conservative position would be vis-a-vis FDR.
Like just in terms of like his ethical legacy, or
His economic legacy.
I mean, I think historically his New Deal platform was pretty favorably remembered, particularly in the sort of liberal idealist tradition. I think that there are several sort of grave sort of moral pox on his for example, like Japanese internment being a particularly flagrant sort of abuse of human rights under the ostensible guise of national security, but at the end of the day, not something that the United States is necessarily proud
You're
of.
talking about FDR now?
Yes.
What did you have specifically in mind?
In terms of like sort of less than moral policies.
Okay, but which policies are we talking about?
Japanese internment.
Oh, yes. Well, there's a big one. Thank you. Can't debate that.
Firebombing of Tokyo, just attacks on population centers.
But what's interesting, everything that you're naming right now, in fact, was broadly held opinion within the United States, probably bipartisan, that those were good things. Now, we can all agree that those, in retrospectively, were bad things. But there was not bipartisan agreement about his economic policies, which is why I keep on trying to narrow the focus here. So what do you think about, what would the conservative position be vis-a-vis his economic policies? He was viewed basically as being a socialist, if not a straight-up communist, right? Certainly his wife was.
I mean, to me it's funny that today that there's such, well, actually even then there's a huge push against sort of his New Deal and writing it as socialism. However, those same people would also fight tooth and nail to preserve their Social Security, which is a platform that FDR made a big push for. So, as someone who supports that platform and someone who finds more than a little bit of hypocrisy in those who would both use it as use Social Security, but while also deriding socialism, seems to me just a little bit hypocritical.
Okay, fair enough. Nonetheless, the reality is that they felt that FDR, by promoting the redistribution of income, was effectively a socialist, and he was not a good guy. So, and of course, he took on, the public works projects, all the things that he did in order to sort of lift up the economy, were viewed as being inherently bad things by conservatives and continue to be so even unto this day. In any event, so let's move forward. The opposite extreme to protect then economic and social rights to the exclusion of civil and political rights, one may argue has negative consequences as well as protecting only political rights. Creativity is blocked, and so potentially is productivity, which is of course what the Cold War was all about. So the entire package, freedom from want as well as freedom from fear, is required to have a balanced and effective human rights system, or at least that has been the consistent position of the United Nations since probably the late 90s. So, from the individual's perspective, economic and social rights are as essential as civil and political rights. Let's examine the right to education, for instance. So I think we've discussed this before. It may be argued that education is a precondition for the effective enjoyment of other human rights. Clearly, in the absence of education, it is difficult to exercise one's vote effectively. If you cannot read newspapers, or if you cannot these days get online and sort of do research to find out, what people's positions are, then the reality is you cannot necessarily vote or cast a vote that is in your best interest. So then obviously if you cannot read, you will have a very difficult time understanding the issues and where the candidates stand on them. Coming from the other side, if civil rights like freedom of expression are violated, one won't be receiving a very good education for what should be obvious reasons. So both sets of rights then are required if one is to have the benefit of either. What about the lack of capability and lack of political will? The question arises not merely in connection with economic and social rights, but actually with human rights generally, and we're going to be really addressing this next week in particular, or next Friday anyway. Why are they not implemented? One may contrast lack of capacity, lack of capability or capacity with lack of will, although the distinction is not always a neat one. So returning to the Asian values case that we discussed many weeks ago, Asian states have argued that Asian values are collective, whereas human rights, especially civil and political rights, are individual rights. The latter undermine the basic foundation of their societies. Clearly this falls in the lack of will category, right? We do not have the political will to change our societies in such a way as to give greater emphasis to individual rights and to raise them up or lift them up and put them above sort of the rights of the majority. Similarly, in the West, especially in the US and the UK during the 80s and once again today, there is and was very little support for economic and social rights, and neoliberalism prevailed. Those who support economic and social rights often cast the neoliberal philosophy as a form of social Darwinianism. Plainly, under its influence, at least in the US, we have seen the death of the middle class, the very heart and soul of our democracy. Again, this constitutes a lack of will. But there is also the problem of lack of capability or capacity, especially in the third world, and this goes not merely to social and economic rights, but also to civil and political rights. So contrary to the Western contention that civil and political rights are cost-free, you'll remember we discussed this before, the reality is that civil and political rights are also costly to implement. They require a well-trained and independent judiciary, among other things, and this in turn requires a heavy investment in human capital. In short, it is not that the implementation of civil and political rights are without costs. It is merely that the costs associated with implementing economic and social rights are more obvious on their face. Let's look at implementation, assuming that ideological differences are overcome. What is required to implement both sets of human rights effectively? To begin with, at least at the domestic level, there needs to be an effort to develop bodies that oversee all aspects of human rights. Individual governmental departments or ministries tend to be sector-oriented and lose sight of the interdependence of human rights. At the international level, some of the same problems can be observed. The World Bank and the IMF, that is the International Monetary Fund, under the influence of neoliberalism have required belt-tightening steps like charging tuition, for primary education is a precondition for loans in other aid. The impact on the development of human capital should be self-evident. And if you don't have human capital, once again, then how do you possibly support the development and implementation of civil and political rights? Accordingly, it has been broadly argued that these institutions should be compelled to incorporate human rights in their activities as part of good governance, and increasingly have been pressured to do so with some success. Moreover, as we have discussed in connection with the pollution of our environment, it has been argued that multinational corporations should not be given a free hand either. And obviously, Kerry Dietrich's case, the issue, I believe it was Nigeria, right? The problem with an indigenous people in Nigeria, that they were not actually being, that their lands were being abused by the Shell Corporation, and they were also being abused. What raises that phenomenon of when a multinational corporation has greater influence in a country than the government of that country. Their involvement in human rights violations has been exposed by the media and NGOs, but this is not sufficient. It has been argued that both the will and capacity of states to regulate the activities of corporations so as to ensure that their activities are consistent with the welfare functions of the state without blocking their positive economic functions must be strengthened. So, among other things, this will require increased transparency within international financial institutions. Next is the question of justiciability, and we actually discussed this, I believe, in the first and second week of class when we were talking about Rosalind Higgins, who argues that a right does not have to be justiciable in order to exist. Accordingly, as you'll recall, she believes that economic and social rights continue to be rights whether or not they are, in fact, justiciable. Increasingly, however, scholars have challenged whether it's even true that socioeconomic rights are not justiciable, or whether this is merely an oversimplification. So what is the definition of justiciability? Well, to be justiciable, the claim must be based on the infringement of a subjective right. Subjective rights are rights, and this you would do well to take down if you're not taking it down in your notes. Subjective rights are rights that would be worded as the right to something, rather than a command to a member of government to do something. Do you understand the distinction there? A subjective right is a right that is actually possessed by individuals that they can take to court and make a claim on. A command to a member of government to do something is not similarly justiciable. So the claim has to be determined by a court or other judicial or quasi-judicial body, and if a violation is found, then the court must be able to offer a remedy which redresses the violation. Finally, the court finding must either set a precedent or at the very least embody an authoritative interpretation of that right. Now clearly that's coming at it from a common law perspective, because if we were talking from a civil law perspective, as you know, judicial decisions are not necessarily binding on parties who are not, in fact, before the court. In any event, a remedy may include a declaratory order, an invalidation or suspension of a law, or constitutional damages. Now, I also want you please to be sure to take this down when we talk about the levels of state obligation. We have encountered the notion that state obligations take different forms. So there are potentially 4 different forms of state obligations. First, respect. This is the negative form of a state obligation. To respect someone's rights is to refrain from interfering with the enjoyment of those rights. Sorry, Matt, that you have to go. Okay. So to refrain from interfering with the enjoyment of those rights. Most civil and political rights are viewed as being negative rights which must be respected by the government, okay? Protect. This is a state's obligation to defend the right holder from intrusions by third parties, including private parties. We already discussed this a bit in connection with the Declaration on religious freedom, right? So, a state's obligation to defend the right holder from intrusions by third parties, including private parties. This would include the cases of protecting children from being exploited as labor by private industry or protecting women from domestic violence. So far we have respect and we have protect. Then we have fulfill. This is the positive form of a state obligation. For a state to fulfill a right means to take measures to ensure the direct enjoyment of the right. As we have seen, although the language of Article 27 of the Civil and Political Covenant suggests that minority rights are negative in form, in fact, Kymlicka, among others, has argued that they are necessarily positive rights that have to be fulfilled. So the Declaration on Minority Rights also, as you will recall, treats minority rights as positive rights. So we are fulfilling, that is to say that we are actively promoting a right as opposed to sort of staying out of the way in connection with respect or preventing others from undermining another's rights in the case of protect, okay? And lastly, we have promote. And that is the duty of a state to promote rights. And yes, it is different from, I'm sorry I didn't say this well, it is different from fulfill, because what fulfill means is I'm taking active steps to make sure that this particular right is implemented, whereas promote requires a state to enable people to exercise their rights over a longer term through education regarding their rights as citizens. While education as to human rights has been incorporated into many human rights instruments, and notably also humanitarian instruments, the promotion of human rights is not relevant to the question of justiciability, except insofar as a citizen must first know that he has a right and that that right has been violated before he can seek legal redress. These levels of state obligations become important later when we discuss how rights may be justiciable, since economic and social rights may not be justiciable at the level of the obligation to fulfill, but may be at the level of respecting and protecting them. But more on that later. Shall we take a brief break again? It's now 3 o'clock. I think it's been about an hour since we took our last break. So let's take a 5-minute break and then we'll go ahead and talk about domestic justiciability, okay? Okay. 3 o'clock. I was quicker than I thought. Maybe I'll go get a cup of coffee. I'll be back. Okay, so I have lunch as well. So, domestic justiciability. Socioeconomic rights have been incorporated into domestic legal systems and subject to litigation by a number of means. First, of course, they have been incorporated by legislation. In addition, some states have constitutional provisions for socioeconomic rights. These come in 2 forms, as a part of a Bill of Rights or as directive principles of state policy, meaning commands to the government that it must do something. Again, these same observations may be made about environmental rights, which have been viewed as being either an extension of socioeconomic rights or, in the alternative, being very similar in kind. Clearly, where there are subjective socioeconomic rights, as are provided for by many Latin American constitutions, they are regarded as justiciable. But where you have a command to the government to do a certain thing, as is found in the Indian Constitution, for instance, are they justiciable? Well, some courts have in fact, or at least some of these commands to the government have in fact been treated by some courts as justiciable, but for obvious reasons not to the same degree. So the value of the constitutionalization of socioeconomic rights is that constitutional norms are superior to national legislation and or executive conduct, and may be used to invalidate or correct both. They also guide courts in interpreting national legislation. Where there are no constitutional provisions for socioeconomic rights, they may be piggybacked on civil and political rights. This is in fact a strategy. Sorry, Linda. Okay. They may be piggybacked on civil and political rights. So this is a strategy of implementation in addition to the integrated approach we previously discussed, and the self-standing justiciability of socioeconomic rights. For instance, if the legislature for any reason grants a socioeconomic entitlement to some people, it must be done on a non-discriminatory basis. So what are the arguments against the justiciability of socioeconomic rights? There are multiple, but I'm going to just look at two of them because I believe they're the most consequential. First and foremost, of course, is limited resources. And the argument against the very existence of socioeconomic rights is that they could not possibly have an existence because obviously there were many governments who who represented countries that were so poor there was no possibility of the implementation of socioeconomic rights. So, where resources are limited, obviously justiciability cannot change that fact. But this goes again to the level of fulfillment. You will recall the three levels of obligation once again that we previously discussed that are relevant to justiciability are respect, protect, and fulfill. So few cases involving socioeconomic rights that have been heard by domestic courts actually went to the issue of fulfillment of that right. Even if a court cannot ensure the fulfillment of a right, they can ensure that they are protected and respected. So all socioeconomic rights are justiciable, at least insofar as the right implies a duty to respect and protect. Where courts have addressed the fulfillment of the right, they have invoked deference to the other branches of the government, as it is not in their domain to prescribe budgetary allocations. Where the argument has not been made that there were no resources, however, then the question for the courts becomes how these resources should be prioritized and who bears the responsibility for prioritization. In the course of judicial review, where constitutional provisions are involved, concepts of reasonableness have been introduced to examine a program implementing economic and/or social rights. In short, resources may be a factor, but not the only factor. Moreover, courts have been reluctant to prescribe the exact nature of the remedy to be adopted. There are always a number of options that could be followed, and the courts leave it to the legislature and/or the executive to determine the exact steps required. Closely related, it is argued that socioeconomic rights are not justiciable because it would lead to the breach of the separation of powers. Budgetary matters belong to the political branches of government and not to the courts. The obvious answer to this is that is just simply too rigid. The implementation of civil and political rights also have resource implications, as we've already discussed. It is possible to distinguish between questions like, is the state under a positive obligation to provide basic needs of subsistence to those who cannot provide for themselves, and the question of how much the state should spend and in what manner. So the first is justiciable, once again. Is the state under a positive obligation to provide basic means of subsistence, whereas the second is not, and that is the question of how much the state should spend and in what manner. So what about human rights between private parties? Again, this is very important, particularly in cases like domestic abuse. So this raises the obligation of the state to protect. Is it something that, it is something that we've discussed at length with regard to women, but the question is whether human rights impose obligations directly on private parties, and the answer is that most human rights scholars would give is yes. But why? Can anybody think why we would wish human rights duties to be imposed directly on private parties? Any answers?
Directly imposed upon whom?
Private parties.
Oh, private parties.
Right. Do you think, for instance, that the United States government or the various states of the United States should be able to avoid their human rights obligations by transferring those obligations to private parties? Let's take the case of private prisons. That there has been a movement towards the privatization of prisons. Would we wish that those prisons could be able to evade prohibitions, for instance, against cruel and inhuman punishment because they're privatized? Nadia,
Yes, right.
what do you think?
I didn't understand the last part of your question.
Okay.
So, would the prisons be able to evade? And I lost you in the other part.
Okay. So what has been happening is that there has been an effort in many states to transfer prisons out of historically, as you know, prisons are owned and operated by state institutions, right?
Right.
So there has been an effort to transfer the ownership and operation of prisons to private entities.
Right.
So then the question then becomes, are those private entities obligated under the Constitution to observe the rights of prisoners in the same way that the state is?
Shouldn't they be able to? They should be bound by the same constitutional restrictions.
And what is your theory? They're private parties. Why should they be bound in the same way?
Because they're performing the same role as the state would. Now that responsibility has now transferred to them, doesn't mean that they can just evade the consequences if they don't follow provisions of the Constitution.
So basically...
So if I run my own prison and you have a couple of prisoners, you're the state, and you were to send me a couple of prisoners, I can't just start abusing these prisoners and just make them live in squalid conditions.
Right.
Without getting in trouble from the state.
Right. So the reality is that, and this is the key concern, the state cannot evade its responsibilities under human rights law or in the United States under the Constitution by transferring such things as prisons to or prisoners to the care of private entities, right?
Right.
And you would not wish that to be otherwise, right?
No, because it would be really bad for our sort of general public, if that makes sense.
Mm-hmm.
The general public would not be too aware if they're going to a private prison or if they're going to a state-sponsored prison. But if they've committed a crime and they are now sentenced to a certain period of time in prison, it should be the same conditions as a state prison.
Okay.
Regardless of where they're going.
Well, maybe not the same conditions as the state prison because, many prisons are horrible conditions even though they're owned and operated by the state.
Right.
But an additional concern is if you privatize something like the prison system, then what do you think is going to be the economic consequences of that? Let's suppose that you have two sets of facilities operating, privatized ones and ones that continue to be owned by the state. What do you think is going to happen? What are these private vendors going to want?
They're going to want more compensation to keep up with the sort of conditions that the state wants, or otherwise they're going to...
I have to tell you, dear, that the states that this is happening in, they don't give a shit about prisoners. But let's go on. So if you are an economic entity, and if you're making a living by having prisoners, what are you going to pressure the government to do?
Increase funding?
Come on, what are you going to get pressure them to do? How do you make money? By filling those beds in the prison, right?
Right.
So what are you going to pressure the government to do?
Give you more prisoners?
Oh yes, and how are you going to pressure them to do that?
I would lobby and say that my facilities would reduce their costs.
Oh, no. How would you pressure the government to give you more prisoners? How do people get to prison in the first case?
I'm not understanding the last question, so that's why I'm having a
difficult How do you go, why do you go to prison?
If you've committed a crime.
And what happens before you go to prison?
You're brought to the face of court.
And what happens at court?
You are sentenced.
Okay, but first you're convicted, right?
Right, convicted, right. That's right.
And then you're sentenced.
Right.
And then you're locked away.
Right, if there's no appeal.
Even if there is an appeal, you're locked away. Okay, and you should note that currently in the United States, most criminal convictions are had through the process of plea bargaining. Okay, very few people see the inside of a courtroom except for to plead guilty to a crime as a product of a plea bargain, a plea bargaining system which notably is highly coercive. So you are a private entity, and the only way you make money is by filling your prison beds. What are you going to do? Andrew, speak up.
If you are a private entity that makes money off of filling prison beds, you're going to pressure your government or the state to convict as many felons as possible.
Hallelujah! Of course! And what population is going to take the biggest hit from this?
The people who are already socioeconomically disadvantaged, which is why in the United States, there's been a lot of talk about how it's a very racialized process, and how incarceration in some ways is the new Jim Crow. There's been books written about that.
The new Jim Crow. Exactly. So that's the reality then, is that what you have is a concern that if private parties and private entities are not bound by human rights, then they will, well, obviously go with it wherever they want in the most cruel and inhumane fashion. Anyway, so the answer then, the question then is, who is bound by human rights? And the answer depends upon the system of law one is functioning in. So there are so-called dualisms, or dualistic systems, or dualism, judicial systems that are characterized by dualism, and this happens to be both the United States and the UK. Although American dualism is regarded as being less extreme than the UK's. The federal constitution, federal legislation, and treaties, according to our Constitution, are the supreme law of the land, according to the Supremacy Clause of the Constitution. Some law, however, is more supreme than others under our system. And this confusion is largely the product of the primary purpose of the Supremacy Clause, which was directed at regulating the relations between the federal government and the government of individual states comprising the United States. So as a result, the Supremacy Clause has been interpreted to mean that the United States Constitution is more supreme than either federal statutes or treaties. Further, federal statutes and treaties are more or less equal. However, they are subject to the last-in-time rule. So that is to say that where the provisions of a treaty and federal statutes are inconsistent, the last-in-time will prevail. But which also obviously means that if Congress doesn't like that, all they have to do is pass new legislation. Finally, most treaties are not deemed to provide for actionable rights within the United States unless there has been some intervening federal legislation. Or put in another way, human rights treaties are not deemed to be self-executing. There has to be legislation to implement human rights treaties even when we become party to them. Now, what about monism? In pure monistic states, or monist states, for instance, France, the act of ratifying an international treaty immediately incorporates the law into national law. International treaty law can be directly applied by a national judge and can be directly invoked by citizens just as if it were a national law. A judge can declare a national rule invalid if it contradicts international rules, because in some states the latter have priority. In other states, like for instance Germany, treaties have the same effect as legislation, and by the principle of lex posterior only take precedence over national legislation enacted prior to the ratification. In its most pure form, monism dictates that national law that contradicts international law is null and void, even if it predates the ratification of the international instrument, and even if it is the Constitution. From a human rights point of view, this has some advantages. Suppose a country has ratified a human rights treaty, for instance, the Civil and Political Covenant, but some of its national laws limit a right provided for by that treaty. A citizen of that country who is being prosecuted by his state for violating the national law can invoke the Human Rights Treaty in national courtrooms and can ask the judge to apply this treaty and to decide that the national law is invalid he or she does not have to wait for national law that translates the international legal provision into domestic law. Okay, how about rights against private persons? Well, one can well imagine that a right against a private person could originate in an international treaty in a monist system. While it is beyond dispute that there are provisions in treaties that either impose duties or place limits on the behavior of private parties in the private sphere, or in the alternative should be interpreted as doing so, it is not clear in a dualist system that they have any effect until the legislature has passed a statute that translates the obligation into binding domestic law. Clearly, the state party to such a treaty has the duty to pass such legislation as part of its duty to protect. But why would we want the duty to go directly to the private party without intervening law? Well, we've already talked about the problem of privatizing and deregulating functions that were previously performed by the state, for instance, prisons but also schools. Hence, if a private party now has a function previously performed by the state, then it should also have the same obligations as the state. Or put another way, the state should not be able to evade its duties under international law simply by transferring its functions to the private sector. So let's go on to the question of freedom from poverty. For a variety of reasons, Chong, the book whom I've asked you to read, or whose book I've asked you to read, questions whether a legal approach to socioeconomic rights is in fact workable. The first issue, of course, is justiciability, which we've already discussed. But he also has deeper concerns about treating socioeconomic rights from a legal perspective. Anybody want to sort of comment on what his concerns are? What is Chong concerned about? The legalization of socioeconomic rights. Actually, his argument broadly applies to the entire human rights project. What's his concern? Who is primarily responsible for the promotion of human rights?
States are primarily responsible.
Okay, states have the obligations, but within states, who primarily is responsible for promoting human rights?
Domestic governments.
Okay.
And NGOs.
Okay. But how are you going to make sure that the state abides by its obligations?
Courts.
Okay, and who is in court?
Legal professionals.
Yeah, who the hell, why has there at least been since the 60s a concern about legal professionals having that kind of power and control?
Because it's a highly specialized field that requires a high degree of education to become a member of that field. And it sort of becomes an elite process that could then be disjoined from overall public accessibility. And also that you have to be very wealthy to access the legal services.
Okay,
so,
well, you don't have to be very wealthy. I mean, there are ways of arranging fees that for instance, contingency fees that protects, enable at least some people who are not wealthy to seek the services of an attorney. But overwhelmingly, it is true that if you probably are not at least of the upper middle class and more and greater, you simply do not possess the resources to fully litigate a matter. And even as to persons in the category of upper middle class, they can very quickly expend all of their resources before the matter is finished. So, and that in fact happens all the time. I just got a call from a guy who had a father who was paying for his son's criminal defense. And he was fresh out of money, and it wasn't finished yet. So the question was, well, how do I transfer this client to the care and feeding of the Legal Aid Society? So that happens all the time. So, but it's not merely that a question of access, although you were right to point that out, and that's an important point to make. It is also an issue of the sort of relationship between lawyers and other specialists of that sort and the general public. And what do you think that is? And this really is his central concern.
I'm sorry, can you repeat the question?
You say that after I just put
I'm eating my lunch
food in my
too,
mouth. Okay, so the question then is, what is the problem when you have sort of this elite group of people who are concerned with promoting human rights almost exclusively, and what is the relationship between these people and sort of the masses, as it were? Do you think it's a warm one?
I sort of hinted on that earlier. It's sort of there's a disconnect because they're speaking. Their concerns do not necessarily mirror each other. So, because if human rights advocacy becomes increasingly an elite practice, the way that it is conducted is going to reflect elite concerns and not necessarily the concerns of the everyman. And you can make an argument that people who have the means and the time and the intelligence to engage in human rights advocacy are the ones that don't necessarily need human rights protections the most.
Which is a hoot all by itself, right?
Which is a theme we talked about earlier in the course, that inevitably law as a whole has historically tended to reflect the desires of the upper middle classes and wealthy, simply because they're the ones who engage in it.
Okay. So when you say that there's a disconnect, what you're really saying is that the Human Rights Project, when it's purely regarded as being a legal one or illegal in nature, is that there's a tendency to alienate the very people that project is supposed to serve. Even if you have, a bunch of goody-goodies like the Legal Aid Society, who are willing to accept lousy salaries relative to their peers in other areas of the law, the reality is that, there is this sense, broadly held sense, particularly in terms of criminal justice, that they're not really there to serve the interests of the clients they're supposed to defend and protect, right? Or to advocate on behalf of zealously. There's a sense that, really, the defense counselors are all really best buddies with the judges and the prosecutors and don't really care about their clients. It's a commonly held belief. So, why do you think that happens? We have only 4 people. Grant, are you still there?
Can you still repeat the question again?
Sure.
You can pick up through text.
Sure. What I was saying is, in my experience at the Legal Aid Society, which notably is a charitable organization, an NGO that protects due process, okay? Mm-hmm. So, even though the people at the Legal Aid Society get paid a nominal amount compared to other areas or other specialization within the law, there is still this perception. Well, first of all, we still get paid more than the average guy on the street, the laborer, what have you. So already that's alienating. But there is nonetheless this perception that we don't care about our clients, that we only care, that we're really friends and primarily serving the interests of the prosecutor and the court. Where do you think that comes from?
I don't think you can, from the average public, especially if you're representing someone, you can completely remove that bias or that sort of mental socioeconomic barrier.
Okay.
Where someone greatly educated is representing you, you automatically think that this person's a step ahead of you and they're not going to fully understand your concerns of the average Joe on the street.
Okay. But
there's no way you can, yeah.
I think you're right about that, but I also think that part of the issue is the plea bargaining system because, they feel like they're being browbeaten into accepting a plea deal, although I think that's largely a product of the coerciveness of the system. It looks like you were about to speak, Andrew. What were you going to say?
That's what I was going to say. When just by the sheer virtue of the fact that you're not well versed in the knowledge and language of the legal profession, you can sometimes feel that you're being handed to you a series of options that you don't necessarily have a choice over. You can only choose from a limited. You know what I'm saying? It feels like you're being handed what you have to do, as opposed to having full agency over what can be done. And because it's like you mentioned plea bargaining, like there can be these behind-the-scenes discussions between prosecutors, so that the judge ultimately with those options that the plaintiff is required to choose.
No, you're breaking up a bit, but I hear what you're saying. So yeah, I think that well, that's obviously the case in the plea bargaining system. I think that's also true in other areas of the law as well, where you feel that you are at a disadvantage. My stepdad, whom I loved dearly, he's passed shortly after my mother did, I guess in 2007. It was very interesting. He was not particularly well educated. He had a high school education. He was very successful in business, but, was hardly an intellectual. So it was his perception, if you started talking to him about something he really didn't understand, that you were lying to him, that you were misrepresenting the truth. Does that ring a bell? That sound familiar?
It's sort of, the thought that I had is, this isn't directly related, but during the most recent presidential election, a lot of people were railing against what they call political class and the professionalization of politics.
Mm-hmm.
And the way that people who are involved in that field tend to speak at a higher level and communicate in ways that they understand, but it doesn't necessarily reflect the public attitude. So I think that's one of the reasons why Mr. Trump was able to sort of co-opt the whole process, because so many people said he was just speaking in a way that they related to a bit more.
Well, and in fact, I just saw a discussion, I think it was last week or possibly the week before, where they were saying, cable channels like CNN or MSNBC, or even, the network news, use political science terms to describe what's going on in our politics. And, the average guy is going, wait, what are you talking about?
Right.
So,
and I've even in my own family discussions since going to college and studying political science, they've said, you're not speaking in a way that we understand. You sound like an East Coast elitist. So there's like this assumption when people, like you said, when people can't understand the way in which you phrase things or word things, they might think you're lying to them, which I think is why we have this attitude of post-truth now. People feel like you can use language to mask hidden meanings.
But in fact, they're not entirely, without the foundation. Let me tell you a story. My mom and I, neither of us being mechanics, drove from Salt Lake City to Las Vegas. And we had a problem. Our engine began overheating because there's obviously a long drive through the desert before you get to Vegas. And so we pulled off at the first exit and went directly into the first available gas station and had them look at our vehicle. They informed us that we had a leak and that we had to have our car repaired at great expense. So we said, well, we're two stupid women who know nothing about engines, and what they did, well, I'll tell you that part later. So we went ahead, we paid the money, we had the engine fixed, quote and unquote, and then we went on our merry way. Second time we drove to Las Vegas, the engine began to overheat. We pulled into the station. We had them look at our engine, making sure that the radiator was adequately full of water, etc., etc. And they again told us we had a leak. What do you think they were doing? It was actually reported, I saw the report sometime later on 60 Minutes, that what they would do is they would take a cup of water, and while you were not looking, they threw it under the car, and they showed you it and said you have a leak.
Oh, dear.
So the reality is there's not, people who fear that they're being misled by elites have a reason to think that. Because it would be easy to do, right? If you have superior knowledge and information, and if you talk in terminology I don't understand, then it would be easy for you to lead me down the primrose path, wouldn't it be?
Definitely. Which is why I do think, even though I don't support Donald Trump, I'm definitely a Democrat, I do think the problem of elite-driven politics and professionalization of politics is an honest one that needs to be discussed. And we need to come up with, for the sanctity of our democracy, we have to find ways of communicating more honestly with each other in a way that we all can.
Yeah, but it's not just a question of honesty. We need to find a way to communicate, period, don't you think?
Definitely. That's why, there's so many divides that are just getting worse in our society, because we don't know how to talk to each other across those divides.
So there's this sort of so this then is part of his concern about, and he wrote this well before Donald Trump was elected to office. His concern is that we are alienating the very people that we intend to serve by speaking in legal speak and by promoting human rights through the courts.
And by NGOs corrupting the process, that's not even helping, because it's just, because I remember he talked a lot about how
I'm sorry, you're breaking up again. I didn't hear the part.
How he wrote a lot about too how NGOs are a culprit in all this too. Like, it's not just members of the strict legal field, it's also that it's become a highly niched advocacy.
Right, and I think there is the presumption that unless and until human rights are incorporated into the law, they're not even human rights, right? And that is also a concern. So, I think he is a bit inconsistent here, because he later argues, like Donnelly, that human rights are the global lingua franca, that is the shared language of moral thought. And this would suggest that human rights are very effective in mobilizing ordinary citizens. The point here is that once human rights gain their footing and become recognized as legal rights, the Human Rights Project has become increasingly inaccessible to the average person. And Chong raises the additional concern that even where economic and social rights have been litigated, excuse me, the litigation tends to benefit only a small number of people and may result in further stratification of the poor according to whether they have a claim that can be litigated or not. So perhaps the most difficult obstacle to overcome then, however, beyond all of these, is the intransigence of the United States vis-a-vis the entrenchment of social and economic rights as binding human rights. To overcome this obstacle, that is the lack of political will in the United States to entrench human rights. So to overcome socioeconomic rights as human rights, to overcome this obstacle, it is really necessary to enter the political realm and engage in an ideological debate, something that human rights lawyers are reluctant to do because it may require sacrificing their status as objective technicians. So here is a situation where their greatest strength is also their greatest weakness. Lawyers that primarily populate the human rights community may not have a suitable background to take on the debate in any case, that is the debate regarding socioeconomic rights. Addressing the ideological issues that prevent the entrenchment of economic and social rights really requires a broad social science background and, of course, an understanding particularly of macroeconomics. Human rights activists would be required to engage in neoliberal theory that only growth can conquer poverty. The counter-argument put forward by Amartya Sen et al., that societies could achieve tremendous improvements in the livelihoods of their poorest members through growth mediated or support-led by policies, even where there is low or negative GDP growth, has gained currency, but it clearly is a minority position in the West. If the public behaves like juries do, where you have two experts taking exactly the opposite point of view, it is likely to turn out to be a wash. And if that's true, if there is a wash in terms of, excuse me, who we should be, in terms of a fight between experts, who does that favor? Woo, goodness. Who is favored by the people just sort of, being alienated because they don't understand the conversation?
Well, I think that when they have just the one expert on exactly opposite sides, you're just going to go with who your base opinion is closest to, because it makes it seem as though it's reasonable to be on either side of the debate. Such as climate change, when they have one person saying, oh no, it's not a thing, and then one person saying it's definitely a thing, even though it's 97% to 3%, but it's 1 versus 1 that you're seeing, so then it makes it seem reasonable to, I'll just stay with what I think, or just not be sure.
Okay, so yes, of course you're right, but let's suppose that you're a jury and you have to make a decision. So,
yes.
So the reality here is that if there is a wash as between expert opinions, if the layman doesn't understand the debate, doesn't understand what the controversy is, and is in no position to evaluate the differences between the opinions of the two experts, then what they're going to do is they're going to stay put. I mean, that's effectively what you're saying, but when I say stay put, they are going to be reluctant to disturb the status quo. They're not going to change anything. They're not going to vote for change because they don't understand where change would lead them. The reality is that we are, or most of us are, very, very conservative when it comes to our own position and status. We are not risk takers on the whole. That's why there are some people who are very wealthy, because they're prepared to take risks. But most of us are more concerned about keeping what we have than taking the risk of getting more, right? Or having a better outcome. And that is also how people respond when they're faced by debates between experts. They don't pursue change because they don't understand what the controversy is about. They don't understand how it could improve their position, and so they're going to stay put and continue, and the status quo will continue. So, I'm sorry, what?
It's like the whole better to stay with the devil you know than the devil you don't.
Exactly, precisely. People are just not risk takers, they are risk adverse. Chong prefers that a moral assault on global poverty rather than a legal one. Chong believes that groups best able to address economic and social rights at the ideological level are members of the social justice movement. And by the social justice movement, Chong means the sustained collective effort to combat extreme poverty through both institutional lobbying and extra-institutional organizing. The movement includes lobbying groups, think tanks, academic institutions, labor unions, religious groups, indigenous groups, and of course influential individuals. The social justice movement primarily relies on moral arguments. And let's back up for a minute. Do you remember what Carrie was saying when we met on Friday? Where do you think she falls in all of this? She started the conversation by saying, I am not a lawyer. My master's thesis was about whether there was an environmental rights movement. And I think that the point we need to understand is that movements are about the grassroots. Movements are about assaulting the status quo by addressing the common man, average Joe public, right? And persuading him in language that he can understand, or her as the case may be. So the social justice movement then primarily relies on moral arguments. Chong points out that the moral struggle for civil and political rights preceded their entrenchment in international legal instruments. It is therefore not unreasonable to suppose that moral arguments must similarly precede the entrenchment of economic and social rights. Nonetheless, human rights rhetoric has entered the field largely because it has become, as I already noted, he said, and maintained the universal language of moral claims. While social justice organizations are increasingly including human rights approaches, it is a new trend, at least it was at the time that he wrote this book, and their numbers are fairly small. When they find it advantageous, they appropriate human rights ideas and language to serve their purposes. By contrast, social justice groups at the left end of the spectrum embrace an understanding of human rights is primarily rooted in international legal standards. They refer to the Universal Declaration on the Economic, Social, and Cultural Covenant. They also tend to make greater use of the legal and quasi-legal mechanisms in their work. So plainly, they more closely resemble traditional human rights organizations in this regard, and as a result are actually more likely to have access to funding through traditional gatekeeper organizations. The vast majority of social justice groups use human rights language to define their work, but tend not to associate human rights directly with international legal standards. The moral approach usually boils down human rights to broad principles such as equality, dignity, and justice. Typically, they express their principles in a form that actually avoids legal language for the reasons we've just discussed. Chong points out that this kind of moral rights rhetoric can often precede legal institutionalization and enforcement, but, and here's the key point, legalization is not a necessary later step for human rights to retain their power as important tools for social justice. Chong argues that this rhetoric is more than mere packaging to get the support of private foundations. For some groups, a human rights approach engenders a profound change away from service delivery or the charity model toward a more participatory, empowering strategy. What is the problem with the charity model? Does anybody know? Why is it actually kind of bad if you really are concerned or have a commitment to social justice?
Well, I was reading that a lot of the money that charities raise actually end up going to administrative costs. And I was reading that sometimes it can be a percentage of 90-10.
Okay, fair enough. That is a problem. But I'm talking about the model, not about the practices of particular organizations. What is the mental set that is the foundation of the charity model? Anybody? If you were talking about the poor, and you have a charity model of in connection with addressing the needs of the poor, what is going on in your little mind? Anybody ever seen My Fair Lady?
With Audrey Hepburn?
Yes, indeed.
Yes, I have.
Okay, so at the very end of the movie, what happens to her dad? Do you remember?
I don't remember what happens to her dad. Doesn't she get together with Higgins?
It's unclear.
I don't remember what happens to her dad.
Actually, it's unclear whether she actually ends up in a romantic relationship with Higgins. But at the very end of the movie, Higgins actually writes a letter to just such a charitable organization and describes her father as numbering among the deserving poor. And this, of course, was at the time of the Industrial Revolution. So the deserving poor was somebody who was poor but didn't deserve to be poor. Right? So when you come from a charitable model, then you are likely to make distinctions about who deserves your help and who does not. Okay? And you choose who the recipients of your aid are going to be. So if you make it a state obligation to address socioeconomic rights, what is the distinction? And why, arguably, from a social justice perspective, is that a better thing?
Well, I mean, it's...
We got three, so Andrew, you go ahead and speak first.
Okay, I was going to say that the state would be less likely to, theoretically less likely to impose sort of moral worth on certain segments of society that might deserve it more or less. They take a overall more holistic macroeconomic approach to which segments get aid, as opposed to, like, with charity organizations, they typically have some bias from another, like they have a religious bias or an affiliation bias, heritage bias, whatever you want to call it. Yeah, so you can avoid that.
Okay, fair enough. Nadia, were you going to speak?
Along the lines of what Andrew was saying in terms of hidden biases within the charity.
Right.
Also, like, hidden motives for the charity as well.
Well, do you remember what the whole big debate was about Mitt Romney when he was running for office? Anybody? They maintained that he didn't give to charities. Do you know why? And what his response was?
Did it have something to do with his Mormon missionary?
Okay, go ahead.
I mean, I know there was controversy that that maybe himself or his sons hadn't served no, it was him, that he hadn't served Vietnam, and his justification was
No, you're way off track. No. I'm talking about what his charitable contributions were. Here's this very wealthy person who's running for office, who is clearly an elitist, and there was concern that he didn't care about the common man. And so they were saying that there was no evidence that he gave to charities. Does anybody know much about Mormonism at all? About how it's organized? The reality is that the Mormon Church is organized to take care of its own in a very big way. If you are a Mormon and you are poor, the church will look after you by a variety of means. But if you are poor and you are not a Mormon, you are screwed. Okay? Because the sense of, there's a sense of obligation to members of the church that does not exist to people who are not members of the church. And one could even argue that that's a means of coercion to get other people to join the church, at least in, you know, the home state of Utah, although I don't think necessarily that was, you know, I don't think they're really that sophisticated of thinkers. Not to put down the Mormon church, my stepmom is actually a Mormon. But the point is that Mitt Romney did give a tremendous amount of money to the Mormon church. He did aid individuals directly within the Mormon church, but he did not give to charities that were not part of that sort of Mormon umbrella. So he was plainly being selective as to whom he aided, although he clearly also was, you know, kicking in a substantial share of, I guess he met the 10% tithe that is required of Mormons when they are members of the church, which in his case was a substantial sum of money. So it was both fair and unfair to say that he was not being charitable, don't you think? What do you think? Is that disturbing? Should you, and how does that relate back to what we're talking about here?
Well, he was keeping within his religious faith.
But he also was really serving the interests, he
Yeah,
was genuinely serving the interests of the poor.
Right. It just within his faith, there is like an underlining of discriminatory sort of biases.
Okay.
Which you can't really, avoid, because he's, again, free to donate to whatever charity he believes in or he supports.
And he happens to support the
church.
Right, it was interesting because when I first met the priest at the church I was attending here upstate, I mentioned he happened to be gay, which was also interesting, and openly gay, which is even more interesting. What was also interesting is I found him really engaging because he was very well educated. He was not merely trained in the seminary, but had, I believe, a master's degree in international relations. And I asked him, well, in light of all that, you know, your background, your educational background, how come you don't work for an NGO? And he says, I am working for an NGO. This is the NGO I want to work for. So, you know, but it was also true that, you know, if you pressed him on the issue, it was not difficult to discover that he had real difficulty with persons of other faiths. So he wanted to serve a particular population and not on terms of equality all populations. So that is why you don't want to be subject to, you know, this sort of discriminatory treatment that you number among the deserving poor, that is to say the poor that did not deserve, did I lose you guys? No, okay. That is to say the poor that did not deserve to be poor. So anyway, even then where it's not primarily rhetorical, it is not empty or meaningless to use human rights terminology where there are strategic implications to framing, naming, or branding an issue in a particular way. Consistent with what he describes as his thin constructivist view, he believes that human rights rhetoric legitimizes ideas where human rights have become the lingua franca of global moral thought. Invoking rights implies a corresponding duty for other actors to respect, protect, or fulfill a right. Human rights rhetoric demands that powerful actors be accountable to everyone, but particularly to the most vulnerable segments of society. It removes poverty from discussions of economic efficiency and numerical cost-benefit analysis. This is, of course, important where efficiency arguments can be employed for such purposes as denying access to medical care for the poor. Neoliberal logic is akin to social Darwinianism and tends not to concern itself with the most vulnerable populations who are faced with daunting poverty, poverty that is in no small part, of course, generated by the uninhibited, unlimited neoliberal system. So what about the problem of justice? The human rights approach enables social justice movements to reframe poverty as an issue of justice rather than of charity. Where addressing poverty is perceived as merely a question of charity, there is no obligation involved. Aiding the poor is purely a voluntary matter. Moreover, it invites judgments about the worthiness of the poor. where a particular individual or group of individuals are in need, the charitable impulse need not extend itself to those that the donor deems in some sense unworthy. It also creates a mental set among the poor that they are internally obligated to those who would help them. So I'm sure you're aware, you've probably heard it in a movie, some old movie somewhere, you gave me a loan, oh thank you know, I give you some money, you say, oh thank you, thank you, thank you, I will repay this, I will repay it by whatever it means I have to. And of course if you can't repay it, then of course there's this sense of obligation that exists because somebody helped you. So it is very difficult, it is a very difficult point of view on both sides than that which is bred by social and economic entitlements. Excuse me. Obviously, where an entitlement exists, it cannot easily be withdrawn. When extending them in the first instance, there is no judgment of moral worthiness of the recipients. The only relevant criterion fundamental to all human rights is whether one is human and therefore entitled to minimum standards of dignity. So the big question is that he keeps returning to is, how do you capture the support of the United States in all of this? Because there exists the real danger that moderate social justice groups will be disparaged as socialist, foreign, and of course un-American. Human rights must be disassociated from distributional substantive equality and instead reconnect it with the notion of a minimum standard below which no one should be allowed to fall. The end goal is to legitimize a justice-based understanding of poverty that changes society's notion of its responsibility to end poverty. Well, this can have an impact on courts whose members are shaped by the culture in which they function, and we've discussed this before, particularly when we were talking about Rosalind Higgins. Chong maintains that political and moral accountability can be just as effective, if not more effective, in ensuring remedies for victims of poverty. Because they are better able to take on the ideological debate, conceptualizing rights as basic moral principles can help subsistence rights activists confront the U.S. government while circumventing the debate over legal rights. They can encourage, among other kinds of commitment, encourage other kinds of commitment to which the state can be held politically accountable, for instance, the Millennium Development Goals. What about human rights and development? Obviously, development and human rights share many traits in common, but they are not the same, and we discussed that when we were talking about Donnelly. Development focuses on the enhancement of capabilities and freedoms that members of the community enjoy. Human rights represent the claims that individuals have on the conduct of state agents and the design of the social arrangement to secure these capabilities and freedoms. As such, Kofi Annan, former Secretary General of the UN, called upon the UN agencies to mainstream human rights into their work in 1997. Unlike the demands for the right to development that emerged in the 1970s, the new rights-based approach does not incorporate explicit demands for massive global redistribution of wealth. Most European state donors have made explicit commitments to incorporating human rights considerations into their aid. In this context, a rights-based approach deliberately and explicitly focuses on people realizing their human rights. It undertakes to expose the root cause of vulnerability and marginalization. It empowers those who have been made vulnerable as a product of poverty, displacement, and war to claim and exercise their rights. The problem is, however, that it uses human rights language and conditions to limit aid to unfavored countries based on a narrow range of civil and political rights and market policies. So really, by incorporating human rights standards into or make it providing aid contingent upon a country observing human rights standards, you may indeed be hurting rather than helping the people that you wish to help in the first instance. And this is always a problem, as you know, with any means of trying to implement human rights standards, that is, to give them teeth. So plainly, this creates then a financial incentive among humanitarian organizations to character economic and social rights in neoliberal macroeconomic terms If they are to survive, apart from cancelling a moral approach, it is unclear how he thinks that this conflict between the American vision and the social justice view of development can be resolved. So the legal approach then is oriented around the technical details of existing poverty law. It encourages the criticism of the relative weakness of subsistence rights law and the validity of economic and social rights as legal rights. It also requires, once again, addressing the US government, which has long been openly hostile to the notion of legal subsistence rights. By simplifying and delegalizing human rights language, moral approaches can avoid the costs inherent in the legal approach and ultimately build the cultural and political support that may, in the long run, make the legal approach most effective. And I am going to let you guys go because we are down to, what, 3 of us, plus me? In any event, is there anything you guys wanted to say or talk about at this point? No? Anyway, I think it is a book well worth reading, as you well know. There is a test question that raises all of these issues. So so obviously it would be well advised to give the book a read and to sort of grasp these issues. But quite apart from that, as I said, the start of our discussion today about the levels of respect, protect, etc., about lack of capacity versus lack of will and so forth, those are also really important issues to get your mind wrapped around. So bye-bye, guys. Thank you so much for staying around for so long, and I'll see you on Friday, okay?
Thank you. See you on Friday.
Thank you. Bye-bye.
Thank you.
Alrighty then.